campaign season in North Dakota, so that means we're going to be talking about initiated measures, although there's not a lot of them this time around, and in fact, none thanks to a ruling by the courts, and I suspect also probably the coronavirus, made it difficult to collect signatures this time around, unless you had a whole bunch of money to pay people to collect signatures, I guess. Measure 3 kept off the ballot by the state Supreme Court because of a drafting issue, so we're left with 2 constitutional amendments put on the ballot by the legislature back in 2019. For those of you who don't know how this process works, there are 2 ways to amend the Constitution in North Dakota. Citizens can initiate a constitutional amendment at the ballot by collecting the requisite number of signatures, which I think is around 27,000 these days. They collect those signatures, they put it on the ballot. If we vote on it, we vote yes, then the Constitution's amended. It is enacted, and that's how that works. The legislature can also amend the Constitution. They essentially pass a resolution. The resolution is then put on the ballot, and the people vote on that as well. And again, if the people vote on it and enact it, then it becomes law. We're going to talk about one of those 2 ballot measures. Measure 1 has to do with higher education governance. Measure 2 is what we're going to talk about today. Measure 2 is a constitutional amendment that would amend the process, the process that I just described. It would amend it so that you'd still collect the same number of signatures, and we would still vote on the measure. But if the people approved the constitutional amendment, then it would also go to the legislature, and the legislature could do an up or down vote. Legislature wouldn't get to amend it at all, just a yay or a nay. If both houses of the legislature approve it, then it's enacted. If the legislature says no, then the amendment is automatically placed on the next general election ballot, and it gets voted on again. If the people say yes again, then it becomes law. It does stretch out the timeline. It does make the process more arduous. I think that those are features of the measure, but my 2 guests now disagree. They don't like Measure 2. Joining me is Ellie Shockley. She is a Bismarck-based researcher, as well as Dustin Gawrylow. He is part of the North Dakota Watchdog Network, and they both oppose Measure 2. Ellie, Dustin, thank you for your time. We had done a radio interview previously, but honestly, I was left. I think it was a good discussion, but when you're working in the radio medium, you have commercial breaks, you have time constraints. It's not easy to have a robust discussion in that setting sometimes. So I invited you on the podcast to keep the discussion going, and again, thank you both for your time.
You're welcome.
Sure thing.
Dustin, let's start with you. Measure 2. Your argument is it makes the process, and I think of all the arguments that you've made against Measure 2 that I've seen, I think that this one is probably the most valid, that it does prolong the process and could exacerbate a problem we already have where the initiated measure process is used a lot by deep-pocketed interests, often from out of state, who come in and they throw a lot of money around and they kind of short-circuit the democratic process and get their issues on the ballot. I mean, most of the time when we think about the initiated measure process, we think of like citizen activists, not paid signature collectors and, lobbyists being paid to go out but that's really what's been happening. Your argument is if we prolong it, we're going to make it, really the only people who can afford the process, to endure it, which would take potentially years under Measure 2, are those well-paid groups, right?
Exactly. Fundamentally, the opposition on a constitutional basis is that these powers are reserved to the people. That's the name of Article 3. We also have a clause in Article 3 that says that the legislature shall not hamper or make the process more difficult. From a constitutional basis, that is an opposition to why changing it in this fashion is not necessarily constitutional in and of itself, which obviously a court would have to decide. But yes, from a practical standpoint, by expanding and extending the amount of time that is necessary to keep the attention of the public to promote an issue, in the worst case scenario where the legislature does use its veto power on a constitutional measure, we take a process that right now, if you start collecting signatures in May, immediately following a legislative session, you've got a year to collect those signatures, and then you've got another 6 to 7 months of campaign to convince the public to vote for your measure. So right now, if you got your ducks in a row after the session, you're running a 18-month campaign, the way it is. If the legislature uses its veto power, you take that 18-month campaign and you turn it into a 3-year campaign because you're literally doubling the amount of time involved in the process. As a result, to keep the attention of the public, I mean, we know how much money it takes to promote something for 6 months. If you have to promote an issue for 3 years, you're guaranteeing that the people that have the money will be able to access more money and do what they are already doing. And the people that don't have money are going to be that much more at a disadvantage because they have to make a shoestring budget, if they have any budget at all, beyond volunteer gas money, go that much further. And so it comes down to, should we be changing the process for the genuine grassroots people based on the few bad actors that have abused the system and taken advantage of the way it works now? And, one of the things that does need to come in, and I know a lot of people don't like to talk about this, Marcy's Law is always used as the example for why this process needs to change. Marcy's Law was promoted by several of the Republican establishment, including the former lieutenant governor's wife, and the number one Republican advertising firm in the state of North Dakota, Odney Advertising, was the entity that promoted and marketed Marcy's Law.
Yeah.
And so when you make the process more difficult, you're creating a situation where you need more money, which means more out-of-state money, because there's only so much political money inside North Dakota. We all know that. And then you're also creating a monopoly situation where if you want to get something passed, you're going to have to go through probably the one entity that has proved that they can do it. And, outside of the folks that did the ethics commission and all that, and they had plenty of money and they had plenty of marketing, if you want to do anything, you're going to have to go through a gatekeeper. And that's not how the system is meant to be. Our system is meant
But that's how it's working, right? I mean, I know you said it's a few bad actors, but those bad actors are the norm because it's Measure 1, it's Measure 2 on the last ballot, the Citizen Initiative. I mean, they paid signature collectors. They had a bunch of out-of-state money. It's Marcy's Law. It was the Outdoor Heritage Bill. Same thing, ton of out-of-state money coming in. One thing, because I do think that this is valid. I think personally, and I hate the initiated measure process. I think direct democracy is just about the dumbest way you could possibly, short of straight out authoritarianism, is just a hugely stupid way of governing. But I also realize that I'm in the minority. If we're going to have it, then I think it should be restricted to what most people think of, which is citizens, and it's not been that. In fact, I would say that truly citizen-led initiatives have been the exception, not the rule, for years now. But so to the extent, I do have a concern about lengthening out the process so that only the professionals, like maybe mercenary groups like Odney, which you're right. I mean, Odney Advertising was involved with Marcy's Law, promoting it, and then they turned around and they fought Measure 3. But they're a company for hire. I mean, they're in the business of doing this stuff. They're going to fight for who pays them. The same way that the signature collectors who I mean, probably it's the same company that that collected signatures for Measure 3, collected signatures for Measure 1, collected signatures for Measure 2 on the last ballot. There's plenty of people that make money off of this, and I don't think that's such a good thing. So I think that I do think that's a fair criticism. But I should point out, you don't necessarily have to campaign that entire time. I mean, you're talking about a 3-year cycle. They don't have to collect. The legislature exercises its veto. They don't have to collect signatures again. It's automatically on the ballot again. Now, they would obviously have to go out and make their argument again, and probably campaign and social media and all that stuff. And you're right. I mean, to do that in a way that's really effective, you either have to have a hell of a message or you got to pay some people. So I think you're right, but you're also, I think, maybe exaggerating it a little bit too.
Well, you've either got to maintain a 3-year campaign or you have to have 2 campaigns. People, I mean, we know that even from the time of a primary race to a general election race, it's difficult to keep people to keep the public at large thinking linearly as far as the candidates. I've seen polling now that shows that, for example, Tom Beadle's name ID is under 30%, but he got 47% in the primary amongst Republicans. That's because in order to maintain people's attention span, it takes a lot of money and it takes constant bombardment in the media. And we're not used to that in North Dakota. Those of us who utilize earned media, we'll get a story here and there every 4 or 5 weeks, and we'll be happy about it. But if you want to maintain the attention span of the public, you've got to be there all the time, and that takes money, and it takes staff, and it takes all the things that the intent of Measure 2 is designed to reduce the need for.
So what is the point? I mean, it almost seems like you're joining me in my argument against the whole. How do you even fix that then? I mean, how do you create a situation where our Constitution is not vulnerable to whatever billionaire comes along and drops a bunch of money?
So just as you have flipped on the initiative measure process itself over the last decade, I've flipped on the campaign finance side of it. I used to be basically an anarchist capitalist when it came to campaign finance. Anything should go when it comes to money. I've come to the conclusion that states need to have the ability to exert their sovereignty to protect their own political systems within their states. And that means developing a way to nullify the idea that any money is free speech. It should be that money that is involved with the general grassroots. I mean, we've got to come up with a way that we can regulate the campaign finance without regulating the speech. And
I don't know that you can.
That's a fine line. I understand.
I don't know that you can.
There's got to be a way to do it.
Because I mean, the problem is who gets to decide that? I mean, who gets to decide who's genuine grassroots and who isn't? I mean, you can look at a political operation like the NRA. The NRA is obviously a little bit on the rocks of late, but you look at a political operation like the NRA. I mean, they're national. They got all sorts of money, all sorts of slick advertising. They also have a very large constituency in North Dakota. It's hard to argue that a group like that is out of state. They're really not. I mean, there's a lot of NRA members here.
Yeah, in 2017, we had a bill drafted and introduced. I believe it was 2336. I might be wrong about the number, but the idea was that we would do two things on campaign finance. Number one, require dollar for dollar in-state versus out-of-state contribution. So if you're going to raise $1 million from California, you got to raise $1 million in North Dakota. If you can only come up with $50,000 from North Dakota, you only get access to $50,000 from out of state. That would create a level playing field where there's the bullying issue is nullified a little bit. Secondly, it would have created a limit for any single donor of 30% of whatever that campaign brings in. They can't take more than 30% from any single person. That provision comes from the rules that I operate under as a 501c3. The IRS says I can't take more than 30% of my annual revenue from any single person. And so there are some ways that we could walk that line. It's probably still going to result in lawsuits. It's probably still going to result in us being a challenge to Citizens United. But I think that there's a way to delicately do it, that we could address the root cause and the root problem on this without punishing the people that don't have access to all this money that has become the problem.
Ellie, Dustin and I have gone down a rabbit hole far from what Measure 2 is. A lot of the ideas, I mean, I think that's a debate worth having, Dustin, and I certainly helped Dustin go down that rabbit hole. I like going down rabbit hole.
Oh, no, it's okay. It's a good rabbit hole.
But Measure 2 is the question before us. And, I struggle. And here's one of the arguments that I think both you and Dustin have made, and I've heard other opponents of Measure 2 making, and we talked about it on the radio. And I got to say, it really bugs me. And it's this idea that the legislature is some other that's twirling their mustache and chuckling to themselves evilly in back rooms to stick it to the voters on the initiated measure process. I just don't think that's true. I have spoken at length. I know the lawmakers who are behind this. And I think that they have a genuine David Hogue from Minot and Scott Lauser, also from Minot. I know these gentlemen well. I don't think that they're out to hurt anybody. I don't think that they're out to try to silence anybody. I think they have a deep and frankly very genuine concern over the way the initiated measure process works now. And they want to try to fix it. And it frankly, it bothers me that people are casting aspersions at their motivations. I think their motivations are genuine. There are real problems with the initiated measure process, and attacking them like this is the legislature out to get people seems to gloss over those very real problems with the process.
Well, then I have to ask, why are they using the arguments that they're using that are just not really, I don't find them authentic or really mapping onto the issue.
Give me an example of those.
And, well, I guess what I'm saying is that if their argument is that the outside influence is the problem, and that's the entire way that they're structuring their argument, why is this their solution? Like, why the solution is just ill-fitting for that problem. And so they're saying we're the correct judges of whether or not the out-of-state influence has been too much, or whatever other reason they might have for vetoing. So there's no guardrails on the logic of the veto that they would like. They just want to have the veto power.
But I don't.
And so
I'm sorry. Go ahead.
Mm-hmm.
I don't think that's true, because I think a check and a balance is exactly this. I mean, we do this all over in government. I mean, it's why. Well, the president was not supposed to be able. Congress is supposed to be a check. We get into a whole debate about Congress not doing their job. But the way the system is designed, Congress is a check on executive power, right? There's guidelines there. So I don't understand why and the reason why we do that is so that we don't have one, sort of authoritarian person who may or may not be influenced by other sources or whatever, that it's got to go through multiple checks. We've always done that in the American system of government. If we're concerned about undue influence, if we're concerned about corruption, if we're concerned about somebody maybe just getting too big for their britches, we put in place checks and balances. That's what I look at this. This is a check and a balance.
I do hear you there, but I think the argument you're ultimately making is that you want to call a constitutional convention and change our Constitution dramatically. And you know what? You have that right, actually. The Constitution gives you that right. And I actually really respect that you're very frank about your skepticism of direct democracy, because at least then you and I and Dustin can have a very frank conversation based on truth.
I think it's terrible. I think direct democracy is terrible. I think everywhere it's been tried, it frankly results in tyranny. I mean, the Bill of Rights itself is a check. It's a list of things saying, hey, people, these are things you cannot do. Right? That's what the Bill of Rights says. It says, First Amendment, you cannot take away my right to say. It doesn't matter how many people vote on it. It's not democratic. I mean, the Constitution itself is anti-democratic. It's a list of things that the people are not allowed to do.
So are you talking about the U.S. Constitution or the state Constitution?
Well, both, really.
Okay, I'm focusing exclusively on the state Constitution, even though, I mean, I'm sure the U.S. Constitution is relevant here. But to focus specifically on that, I think, like you said, your view is in the minority, and I think a lot of your listeners are a little more receptive to a role for direct democracy in their governance.
Sure.
And it is just very clear in our current Constitution that it plays a role. Yeah. So, I mean, it's totally fine for you to feel like our Constitution needs some work. And in fact, the Constitution is the thing that protects your ability to do that work. But it's just very clear. Article 3 is based on citizen powers, and Article 4 is based on the legislature. So if the legislature wants to change their own powers, it should go in Article 4. Article 3 is what they're seeking to modify. And, I agree with Dustin that the language here is very important. Powers reserved to the people. In fact, so it details what our powers are, and it does include constitutional amendments. And then it says laws may be enacted to facilitate and safeguard, but not to hamper, restrict, or impair these powers. So as long as that sentence is in there, And that's what we're living under right now. And so this is an attempt to make this section of the Constitution incoherent. And for me, I think that that's just really damaging. And if you talk to North Dakotans about why they like the access to direct democracy we have, it is because they feel that the legislature doesn't always provide the policies that they want, and they want another avenue. And so this is why our Constitution is the way it is. And if you just don't like that, that's okay. But I know plenty of your listeners do. And I'm here just to tell them that I also like it. I do not think it's perfect. I do not think any of our institutions are perfect.
It's not that I just don't like it. I think I've articulated a pretty clear philosophical argument against it. And again, the initiated measure, I realize that my overall objections to the initiated measure process are in the minority. What I don't like is this idea that we're holding it up as a sacrosanct thing that cannot be, changed by anything else. I mean, you talk about the Constitution powers reserved to the people. Well, the people are being asked to make this change. The people are allowed to say, okay, well, we'd like this change to be mixed up a little bit. And if the people say that, is that not a reflection of the will of the people?
Well, if it's right there that these laws cannot be enacted, it seems to me that the first step would be to change that language, and only then could you even make a change like this. So it just it doesn't add up. Honestly, it just seems a bit sloppy. And I'm totally okay with you saying that these legislators are well-intentioned people. That will very well be the case, and we can still disagree with their power grab, even if they have good intentions. But I'll tell you who doesn't have good intentions is Jamal Omar, who made a spoof website to trick folks into conflating the pro and anti Measure 2 camps. And so there is a deceitful campaign to try to.
I wasn't aware of that.
Yeah. Oh, it's a brand new finding of ours.
Okay.
So there is some, and so I'm not going to say that I have no idea who he's collaborating with on this, and I'm not going to blame the legislators for his behavior. It's unclear to me what exactly is going on.
These debates should be, and I appreciate that you. I am not a fan of people hiding their motivations. I speak plainly, and I'm not afraid to lay it on the line. You usually don't have to wonder where Rob Port comes down on an issue, because I'll just tell you. So I don't like subterfuge like that. So if somebody's doing that on Measure 2, and apparently they are, I don't doubt your word on that, knock it off, because that's stupid, and let's have a debate on this on the merits. But I think the merits are clear for Measure 2. Dustin, if Measure 2 if Measure 2 passes, do you think we would see fewer constitutional amendments? And maybe isn't that a good thing? I mean, we're talking about the Constitution. Why shouldn't it be hard to amend the state constitution? At the federal level, it could take years, because not only do you have to get supermajorities in Congress, but you also have to get a supermajority of the states to ratify. I mean, that process, it has literally taken decades at times for that to happen. Why shouldn't it be hard to amend the state constitution?
Well, I think that it's not necessarily that it shouldn't be hard. It's that the making of it being harder should originate with the people rather than the legislature. If we want to talk about legislative intent on where their heart is, we can look at a list of all the things going back to 2013 that the legislature has passed or tried to pass. Let's remember that this current phase of trying to make the process more difficult did not start with Marcy's Law or the Ethics Commission. This started after 2012, when the people, in a grassroots effort, tried to abolish property taxes, and that scared the hell out of legislators. It didn't.
I don't think that's true. It didn't even get 30% of the vote. Trying to say that legislators are reacting to that. Come on.
Well, but that's when
that went down. That went down in flames. That went down in flames, Dustin.
Right.
Come on.
Right, but in 2013, the legislature had a half dozen approaches to making the process more difficult. Two of them went to the ballot regarding the timeline, and then what kind of measures could be on the ballot. They had in 2013 was David Hogue's original concept of creating a legislative review committee to look at measures and determine whether they're worthy of being on the ballot. We had things like they wanted to require 4% in every county or 4% in half the counties.
Yeah.
For signatures, in every session, 2015, they didn't want things with major fiscal impact. Well, that would have prevented any tax cuts from ever being on the ballot.
So some of these ideas may be good and some of them may be bad. But here's my problem, Dustin, is you keep impugning the motivations of the legislature. Now, you may not like their ideas for reform, and you may think that they may do more harm than good, but even you yourself acknowledge the initiated measure process has problems. So why attack people who are, even if you don't like the solutions, at least they're trying to come up with something to fix this.
But their solutions, what they come up with, are only designed to make it harder for people who do not have resources to use the process. It
should be harder for everybody, really. I mean,
none of these proposals have ever addressed the real issue of well-funded entities being able to run roughshod over the people. None of these do that. So if their motives are pure, then their approach should be a little bit more focused. But it's not. The idea last session there was a bill or a resolution.
But we're also talking about a body that has a lot of people in it. I mean, and a lot of them have very even within the two-party ranks, there's often a lot of disparate ideas on what's good reform and what's bad reform. So I mean, just because a lawmaker introduces a bill, that's not necessarily representing the attitude. We talk about the legislature monolithic. It's not a monolithic body. There's a lot of different people there with a lot of different views.
Right. But we also know that there are a handful of people that have been pushing this agenda for the last 10 years.
I don't think that's true.
I can prove it by the fact of who put their name on every single resolution.
Name names.
David Hogue, Dick Dever are two primary ones. They put their names on every single.
So do you think that's like a cabal or a conspiracy, or do you think maybe those are just two public?
Do
you think those are just maybe two public servants who are concerned about an issue of
agenda?
Okay. Well, they're legislators. Yeah, every single legislator we elect has an agenda. I would hope they do. I hope they're not just going to Bismarck to bob around in the political circles. I hope they all have an agenda.
If their agenda is to make the process harder, they don't really care how do they do it. They've been
I don't think that's true.
Doing a shotgun blast approach for the last 4 sessions, seeing what they can get stick to the wall, and measure 2 is what finally stuck to the wall.
Maybe that's true. Which maybe speaks to them. I mean, the fact that this has been such an arduous process, even for the legislature, might speak to the fact that they are taking it seriously. And again, I'm not in the legislature, and I'm not here to be the legislature's spokesman. It bugs me that we can't just have a debate on the merits. We have to, they're twirling their mustaches. They're terrible people because they want to touch the initiated measure process. Well, maybe the initiated measure process needs reform. I think we've actually, everybody, Ellie, I don't know, you can weigh in. I think everybody knows there are problems with the status quo, right?
Yes, there are so many other options, though.
Okay.
I think we can consider, for example, voter information guides. So, people really have to rely on the media to give them education about ballot measures. It doesn't actually have to be that way. We could, generate some appropriations to pay for, and I know people don't like paying for things, but sometimes you get better governance when you pay for something. Paying a bit for education for voters. You can have the pro and con side of any given measure provide information to the Secretary of State or Legislative Council or whatever institution would be correct to then send voter information guides to households. So they have a list of the arguments vetted by the actual pro and con sides of a given measure where there's an opportunity to say whatever you need to say if you're on one of those sides, and then have the voters weigh on it. I mean, it's interesting is that actually I think a lot of the labor of informing citizens is actually put on people like you, Rob, and others. So you guys are doing like civic education, and that's wonderful, and I'm happy to do that too. I'm very passionate about these things, but people actually deserve more, and they shouldn't only be counting on us to understand these things. And so we have options of educating people if that's an issue. We have options. We could connect these activists with resources to ensure that the measures fit with our framework, so that, Marcy's Law actually, I don't know if you guys feel this way, but I feel like Marcy's Law looks odd in our Constitution. Like it just genuinely is kind of out of place.
It should be in statute. It shouldn't be in the Constitution. That's
fair enough. But we know, I will just speak for some people who say the reason that the Constitution is sought out as the place to make the change is because it's not trusted that the legislature won't immediately kill whatever was put into statute. And so, people are.
When has the legislature ever done that, though? I mean, people say that. When has the legislature done that?
I couldn't say, and I would have to ask Dustin if he happens to know.
I mean, there's the medicinal marijuana measure, but they didn't kill it. I mean, they reformed it. I mean, the medicinal marijuana measure was a statutory measure, by the way, which would not be touched by Measure 2 at all. But the medicinal marijuana measure was a mess.
They drafted that wrong. I think that the last time the legislature actively attempted to very quickly change a approved ballot measure was probably the tobacco measure.
It didn't work, but it failed. They've never done it.
I believe Al Carlson.
Yeah. Well, that was the one where at the end, I know what you're talking about, because Al Carlson had to stand up. Like, it was at the end of the session. He had to stand up and say, listen, fellas, we have to appropriate this money because the voters passed it and we don't have a choice. I remember that. It wasn't successful.
Yeah.
And that was my point. When have they ever done that successfully, other than the medicinal marijuana measure, which people get so upset about that. If the legislature hadn't touched that law would be unworkable. So
it was probably a couple decades, I would say, before that, because they learned their lesson for a while. And that's part of the initiated measure and referral process is it's designed to give the citizens a way to teach legislators a lesson. The Democrats learned the lesson in the late 80s. The reason that Republicans took charge as quickly as they did in the 90s is because Democrats overplayed their hand, jacked up taxes, and the people had to slap them down with the referrals in '89.
Yeah. Although I think referrals are a much different thing. I am actually great with the keeping with my philosophy about checks and balances. I like the referendum process, and I see it as completely distinct from the initiated measure process. The initiated measure process is initiating the legislative process solely and exclusively at the ballot. A referendum is the electorate exercising a veto over a bill that the legislature has passed. I am very much for referendums. They are distinct from initiated measures, which are a much different animal. So I like referendums, and I don't understand that people.
The power is reserved to the people, and as our Constitution sits and has sat for 100 years, that it's one thing. It's one power that the people have to keep the legislature in line. And there used to be a publication that came out from the Secretary of State's office, as Ellie was describing, with pros and cons. Both sides were allowed to buy pages. It was like you could pay $2,000 a page or something and get your information in there, and then they would distribute it out to the counties and stuff like that.
Maybe. Are people going to pay attention to that stuff? I don't know if they do.
Well, whether they do or not,
Ellie thinks so. I would read it. Ellie's a nerd like me. We'd read it, but I'm wondering about the average voter that doesn't tune in till.
And obviously, you don't have to print it out anymore. It's got to be online. But the idea is that there's got to be a central, concise way to look at each, and that's not the solution. Frankly, when it comes to putting statute into the Constitution, I have suggested in committees that we could actually put a word count limit on the Constitution. Let's limit it to 300 words. If you can't amend the Constitution to do what you want in 300 words or less, you probably should be in the Century Code.
Well, that was one of the things with Measure 3 too, is they did so many different. They lumped in so many different proposals. I mean, we're doing jungle primaries now. We're doing ranked choice voting in general elections. We're moving military voting around. They're doing all these different things. And it's this huge amendment to the Constitution, and I just worry, is the average voter paying attention? I mean, they're going to understand all the nuances of that on the ballot with no other checks and balances or scrutiny? Come on.
Well, Rob,
Right,
I think
right.
that Measure 3 would have just failed. Honestly, like I've
Part
done
of me
a good
wishes
amount
the
of
court
research on this.
part of me wishes the court hadn't struck it down so that it could go down in flames. I think,
Well,
unfortunately,
yeah, it would have been interesting to observe. It was very complicated, and it's well established in research in and out of state that excessive complexity is not something people are looking for in measures. They want something, more simple they can wrap their minds around. And so, you dig your own grave when you make an excessively complex measure. But I just want to say that, look, if other people are insulting the legislators who are behind this as individuals, that's fine. That's not what I'm doing. But let me just say that legislators have broken trust based on their own behavior. And that's not my fault. People are upset about the marijuana issue, and that's what's broken some of the trust. And so, if you don't respect,
do you think the legislators
needs.
should they just have left medicinal marijuana alone so it didn't work?
Well, I'm not necessarily saying that, but I'm saying that there wasn't good communication with citizens. Citizens got the feeling that this was just being delayed, and that there was also just a lot of negativity in the way that legislators communicated their thoughts on these issues. There just doesn't seem to be a lot of respect among a number of legislators towards constituents, and constituents are feeling it, and they are then mirroring that disappointment and disrespect. Yeah. And that is their own fault. And so, we're in this situation because of, sloppy choices or representation that isn't very precise. And I'm sympathetic with citizens. Citizens are asking for more respect and better representation. And that's what this is about. But actually, it's not what it's about. What I mean to say is, at the end of the day, it doesn't even really matter, who's being a meanie or who's being a jerk. This is, this ballot measure is pretty simple.
Sure.
It is asking for a veto on constitutional amendments passed by the people, even though the actual same Constitution says, no, you can't make laws like that. And so, whether or not people are well-intentioned or poorly intentioned.
I don't agree with that analysis. Let me ask you this question, though. If Measure 2 had come from the initiated measure process, like if there was a citizens group that went out and they gathered signatures and they put this exact amendment on the ballot, would you guys feel differently about it?
I think my conclusions or my arguments would be very similar.
The end result would be the same. We would lose the ability to say that it was a legislative power grab, because the measure that I started to.
So maybe we should stop talking about the legislative power grab so much and just focus on what Measure 2 would do. Well, I mean, maybe this idea that it's a legislative power grab just needs to go out the window because it's not really relevant.
But it is, because they're the ones initiating this change. So if they started it, they're the ones doing it. Getting to the idea of where these things should happen. I believe that Article 3 should only be changed using Article 3. Like the legislature shouldn't have this.
Yeah. You had a ballot measure to that effect, right? And you didn't get enough signatures.
Yeah.
You kind of ran into the coronavirus thing too.
Yeah, and getting back to your statement about medical marijuana. And should the legislature have just left it alone? Yeah, they should have left it alone, and then the people who brought it forward should have done another initiated measure to fix their own mistakes. Why was it the legislature's job to fix the mistakes?
Because they're the legislature. They have the legislature, and they probably have a duty not to let poor, unworkable code into the law.
The people put it in, not them.
Okay,
but
the people also elected the legislature to legislate. Which gets to another problem I have with this whole thing is okay. We get this idea that the legislature is just going to act and they're going to veto these things. The legislature also has to get elected. We have elections every year, and people say, well, they're not respecting their constituents. Well, I guarantee you, most of the incumbents are going to get reelected this year. For all the
many are unopposed.
Yeah,
many are unopposed. And
yeah.
So I guess
where's this hue and cry that the legislature is doing such a terrible job representing the people?
What I'm just saying is that there are reasons why people are running unopposed, and it's not because voters don't want competition or don't want choices on their ballots. It's complicated, and so just to assume that every legislator is,
most of them have challengers. I mean, most of there's alternatives. I mean, the number of legislators who are running unopposed is the minority by far. Most of them do have challengers, and I don't know. I mean, I have a struggle. I mean, if it's all about listening to the will of the people, if they keep sending the same people back to the legislature, is that not also the will of the people?
I mean, consider this: Hogue and Macy do not have challengers.
Okay.
I mean, and there's some of the gentlemen who have put forward Measure 2. And so I'm just saying that people don't even have the opportunity to choose someone else at this point. Whose fault is that?
It's not that hard to get on the ballot.
That's another podcast.
Yeah. It's not that hard to get on the ballot.
There are a lot of reasons.
Yeah.
You're right that it's not hard to get on.
The will of the people, I mean, that question, Rob, can be flipped reversed too, is why don't the legislators that trust the very people that sent them there to vote on these initiated measures?
But couldn't you make that same argument like if a president issues an executive order and then Congress does something and takes that power away from the president? I mean, both of those people were elected. Both of the the president and Congress are both elected, and we know they often have contrary ideas. I mean, even presidents who are working with Congresses that are controlled by their own political party have friction between executive branch and legislative branch, but they're both elected by the people. This stuff's not as clear cut sometimes as I think you want to make it, Dustin.
It's a check and balance thing, and I believe that the people should be a check on the legislature. The legislature does not need to be a check on the people.
Why not?
It's a government of the people. If the people determine that the legislature should operate under a certain set of rules, they should operate under those rules.
Okay, but we put checks on the people all the time. Like I said, the Constitution, and including, and by the way, a lot of the rights in the Bill of Rights are mirrored in the North Dakota Constitution, and that is a check on the people. You cannot. The U.S. Constitution
is a list of things the government can't do. It's not a list of things people can't do.
Yes, it is. Yes, it is. It does not matter if we got together and you put a ballot measure on that would abolish the right to own guns. That would be struck down by the courts.
Sure.
Because it would be unconstitutional.
Sure.
Yeah. That's what these laws are. Is there a list of things that we can't do to each other?
Well, no. The Bill of Rights is preventing Congress from banning guns without an amendment process to the Constitution.
But Congress, the Constitution applies to the legislating that the people do at the ballot too. I mean, there's not an exemption.
It does, once it's challenged in court. But as the legislature, remember, the legislators always like to use this statement: it's legal and constitutional until the court says otherwise.
Yeah.
So our North Dakota legislature passes laws knowing that they're unconstitutional, but they're not going to be declared to be such until the court tells them they are.
Right.
That happens all the time.
And it can happen, and that's not my point. I mean, the people could do the same thing. I mean, you could go out and say, well, this will probably get struck down by the courts, but it's the right thing to do. So the people could do that too. I just don't understand why. I mean, you say, well, it's the power and it's absolute and only the people should get to do this, and that's bunk. We don't do that any other part of our government, and I don't think we should do it with initiated measures process too. The law should protect the minority. Right? I mean, the laws a lot of times is to protect unpopular things.
Look at the we still have in our Constitution a provision that says that marriage is between a man and a woman, even though that's no longer the law of the land.
Right. Court
doesn't
struck
matter
that
if it's
down.
in the Constitution. Doesn't mean it's executable. It doesn't mean it's enforceable.
It was put in the Constitution by the people. I mean, that's one of the fears too, Ellie, that I have with direct democracy is that a lot of times the people throughout history have believed some pretty ugly and bigoted things, including opposition to gay marriage. I think if that was put to a vote today, I think most North Dakotans would probably vote for it. I don't know. I think the reviews on that have evolved a lot. But you look in the past, some of the Jim Crow laws and a lot of these things, that's what I don't like about direct democracy is this idea that you could just get a majority together and pass a law.
But we also know that Jim Crow existed as it did because the elites actually in power set the statutory tone and basically
reflecting probably the will of their constituents. I mean, you're telling me that Jim Crow didn't have popular support in the South?
It had popular support because of a long-term ideological push to see Black people as inherently inferior so that lower income whites and Blacks wouldn't come together.
But do you think that's a mistake is blame? Because I think we do this in politics all the time where we blame people at the top and we say, I think a lot of times the politicians are giving us exactly what we voted for and they're giving it to us good and hard. I think actually legislators are very responsive. It's just that the public wants contradictory and often very stupid things.
I hear what you're saying, and I think that's why, first of all, governance is just hard. And I think, this conversation is exciting because it's just demonstrating the 50 experiments in democracy happening in our country, and we're one of them. Yeah. And I do think we have to remember that even though self-governance, the Republican system, is the way that we're doing things, we do have to remember that tyranny of the majority is not desirable, and we do need to have protections in place so that things don't run out of control. So needing some guardrails on these issues, you're right on, and I agree with that. I don't think that this is one of those times, though, where things are just running so crazy that we're ragingly oppressing people, even though those risks are real. And so I do take your point that there are bottom-up and top-down forces that can cause bigotry, authoritarianism.
I think there's probably, you to use the Marsy's Law, and I realize that maybe people are using Marsy's Laws as a little bit of a boogeyman, but it is an egregious example of the problem. And we can, obviously we're having a debate about whether or not Measure 2 even addresses that, but there are criminal defendants in the state of North Dakota who have not achieved the amount of justice that they could from the criminal justice system because of Marsy's Law. And we did that. Criminal defendants are not a popular constituency, right? I mean, we fight all the time. Look at how the paltry funding for the public defender's office. That's how politically popular criminal defendants are. And so Marsy's Law, I think, is an example of exactly where the popular idea is we're going to protect victims and to hell with the rights of the accused because they're probably guilty anyway. That's a very majoritarian outlook, and hey, it was successful. It won. That's in our Constitution now, to the detriment of justice in North Dakota.
I think that's fair, but I think that I don't necessarily trust that legislators are really, really excellent at consistently protecting people who need to be protected. And so the idea that the ordinary voter is sort of uniquely poised to oppress other people, I just don't think that's borne out by the facts.
You're right, but that's why the legislature has checks and balances. That's why the governor's office has to sign off. That's why we have the courts. It's why we have the referendum process where the people can veto a bill if it's that unpopular, which people have used in the past. And in fact, we have a recall process as well, where if you think legislators getting out of line, you can recall them and put them on the ballot. I think those things are all good things. I just don't understand why the initiated measure process can't have the same checks and balances.
Maybe you can have a check or balance that's just better tailored to the problem that we're having. We're saying that this is just not the solution.
Yeah.
And I'm not going to pretend like I have a solution drafted, ready to go to collect signatures on today or anything like that. But I'm interested in this thought process of thinking about, well, what would a solution really look like? And I find this discussion, that's why I said it was a good rabbit hole that you guys went down earlier, because I do think that's a really good intellectual exercise.
Yeah.
I just think that this is an ill-fitting solution.
Yeah. I mean, that is the nice thing about Measure 2. I'm glad that people are talking. I can tell you, and Dustin knows this, when I turned on the initiative, because Dustin and I have literally, Ellie, I don't know if you know this, Dustin and I have collected signatures together for initiated measures in the past. I soured on it in a big way. And I think a lot of it was around the Outdoor Heritage Fund when a lot of those measures were coming through. And it was just exhausting to have to argue against and fight off these terrible ideas that were backed with all of this money. That's when I came to the conclusion that the process is really broken. And I guess maybe had a little bit of a change of heart. I think we've done this issue justice. Dustin, if you have any last thoughts on this before we wrap things up.
I think that we need to look at the history of how we got here and be more open to discussing the campaign finance side of things. And if we're going to if Measure 2 does not pass, we do need to come up with a solution that protects the actual North Dakota citizens' ability to use the process without it being abused. And so, hopefully the folks that are pushing this will realize that, the time to come together and come up with that solution, even if it means lawsuits and court cases. The state needs to exert its sovereignty, just as the people need to exert their sovereignty when it comes to legislature.
Ellie, last thoughts?
Sure. I'll just share with folks that if you do share some of these concerns with the initiated constitutional measure process and you are seeking solutions, that's totally fine. We take no issue with that. And we support you investigating solutions. This is just not the solution. This is an ill-fitting solution. This just simply gives the legislature a veto over us for any reason they want, not because of some sort of out-of-state influence. And so a better solution needs to be crafted ultimately. And also, it just damages the quality of the document. It literally makes the Constitution incoherent, and that's just not the right way to approach it.
Yeah. Marzy's Law probably bad damages the coherency of the Constitution as well, but we are where we're at. I do like that. I think we found some consensus on the fact that there are problems with the status quo. I'm a little skeptical of saying, well, this just isn't the fix, and then not offering any reply. I mean, how do we – because I guess you could just always say that. I mean, Dustin, I guess, is talking about campaign finance reform, and I don't know how the libertarian in me feels about that.
Single subject limitations, word count limitations.
Ban on paying people to collect signatures? I'd like to see that happen.
I would actually be for that at this point, because it just, at least at the level, I mean, that's one of the things.
One company, $1.3 million since, I think, 2016 to collect signatures.
And the irony is, we have a law in place that says you cannot pay people per signature.
But you can pay them by the hour.
You can pay them by the hour and then require them to, hit a quota mark
or get fired.
And then never mind the fact that there are signature collecting companies. When Kanye West was collecting his signatures, they were offering $8 a signature.
Yeah.
So these companies don't even know the laws, and they're in here playing around. That's probably a law enforcement issue at the AG's level, but that's entirely a different issue.
Yeah.
That's a fair point, and I'll just say that, I'm just one person. I never pretend to have all the solutions. So just because I'm not able to cough up the right solution at this moment doesn't mean there aren't a whole bunch of brains in our state who couldn't come together and come up with the right one.
Well, I hope, because I feel like if Measure 2 fails, this debate ain't over. I think we've certainly seen that with previous, and I hope that you two will support if some of these other ideas can maybe come out of the legislature, or maybe an initiated measure. I don't know. That would be an initiated measure I could get around, is limits on the initiated measure process. I'd be okay with that. But I thank you both for your time. I appreciate it. Good debate, and we'll talk again.